but will not get not listed.
What you
Because
buy
of a
is
lot
not
of
happening.
stay out of
Yes, yes.
Press admission item number 1.
Yes, my lordship.
It's my learned senior Dr. Singh.
Yes, yes.
Mine is my learned senior Dr. Singh. These on VC for mention.
Yes. Which one?
Item 1.
Yes. What is this?
Yes, my lordship.
What has happened is, Malas,
Repetition
may I-
Oh,
Yes, I have.
Dr. Singh is appearing for mention.
we can't
Malas,
see it.
can I?
Look at it.
Malas, can your lordship see me and hear me, Malas?
I think there is some lighting problem. Your face is not
Lighting
visible.
is there, Malas, but as long as the lordships can hear me, Malas, I can just take a chance in 2 minutes. I know there is a
lighting of an intellectual excellence is well done.
no, Malas, there is some problem with the lighting. I'll just take 30 seconds, Malas. Your lordship will recollect that your lordship, Malas, directed that there will be, Malas, notion and adverse nature. It's a very simple thing. This will not oppose, I think. I have
Your
a sponge iron plant to which this product mineral goes.
You are for the
Yes.
Hear me? The application is very simple, Malas. The state will not object, I hope. That Malas, there is a sponge iron plant which is to be supplied with the mineral.
So, my lord, my matter is item number 1.
meaning for listening.
Yes, ma'am.
Are you
Malas,
doing
it's
this
for
20th, 20. Yes.
It's coming
This
on
is not 20th.
I-
Tell him.
I-
Or there is technical glitch. Tell him over the telephone. Technical glitch. Yes, call
Yes,
the item number 1.
yes, my lordship. I am for the
What is
petition.
this item?
Yes.
Annexure 2 and 3.
Yes, Annexure 2 and 3 is about the some allegation about employment of by
That
producing
wanted
educational certificate.
everything to be done in a time-bound manner. What is this Annexure 2 and 3?
Yes, 2 and 3, my lordship. It is a representation to the irrigation department
The
division.
difficulty is that I can't read those documents.
Yes, my lordship. Some employee are getting the employment.
My difficulty.
It is my fault, my lord.
My lord, my
Do
So
not give a translated copy, sir. I can't read this script.
yes,
You know very well.
yes, my lord. Some employee are employed by producing fake certificates.
This annexure number 2
Yes,
does not contain any material, simply by saying that by dint of fake certificate,
yes,
certain persons are employed.
yes.
So there is no material.
No, there is a material after prima facie, the IIC has already taken note of that and written a letter to the irrigation department. My lordship, I am
Inquiry is going on.
no only they have written to the
With respect to
irrigation
11
department.
With respect to 11 employees,
Yes, 11 employees
they
sought a report to the irrigation department.
their school certificates are fake.
Yes,
You are alleging.
yes. Annexure number 4, my lordship. The IIC of Nimapada police station have already written a letter to the superintendent engineering irrigation department of Nimapada to produce the certificate of those people who are obtain employment there by producing fake certificates. From the certificate itself, my lordship.
Who is to inquire? The police has returned to superintendent of engineering.
Because under the superintendent engineering irrigation department.
Can a duplicate be styled as knockle? Knockly, sorry. What is the English meaning of the word knuckly? Duplicate.
Duplicate, my lord.
Duplicate.
Yes.
Duplicate means it is a replica of the original.
No, it is a fake.
Is that fake?
Yes. It is a fake certificate, my lord. From the certificate itself, my lord, the page number 12, the issuing authority
It's going on, so what we
She has to inquire.
that is what is there. So how can we direct that? They're taking, they have approached to the headmaster also. Resident engineer, they will ascertain it. These are again one concept.
My lord, see page number 12. The issuing authority itself said it is a fake certificate.
My lord, they have made allegations against the 10 persons, my lord.
11
But 10 persons are not made parties here.
Who has said? There is a,
My lord, here in the
who
representation,
says that it's a fake certificate?
My lord, page number 12.
Yes.
The office of headmaster. One certificate.
Headmaster has been approached, he has not said, sir.
Yes, my lords. He has a page number 12. I got this information through RTI. He certified that Lakshmindra Malik, one of the employee, Lakshmindra Malik.
Sir, page number 12 does not say so. Certified that Lakshmidhar Malle,
Yes,
son of such and such,
yes,
has taken admission on 9783,
Yes.
Parampur such and such,
my lordship.
but the TC has not been issued. TC is a different, that's a transfer certificate.
No,
He took the
that
admission.
yes, my lord, transport certificate page number 10. TC number 309. That is a fake one.
I do not know. That
Yes.
is not a fake one.
Yes, my lord, 10, page number 10. The certificate Lakshmindra Malik.
So,
By producing this certificate, he got the employment there. TC number 309. Page number 10, my lords. That is the TC number 301.
no, it's not. And what is the last one?
My lord,
The letter is written to the headmaster of the school.
yes,
Then no response.
no response, my lord.
So-
This letter was written by the Superintendent Engineering Nimapada Irrigation Division to produce requested to look into the matter personally and corporate our staff. But after that, no action has been taken. No step have been taken. Though assistant engineer and junior assistant are deputed to attend your institution on 9/1/2025. Individual letters are issued in name of that employee to the concerned headmasters.
The letters have been issued to the headmaster.
My lord, page number 13.
Then maybe you have not made them parties.
Yes.
No, my lord,
That too, because any order is passed
no,
declaring that this certificate is a fake. Do they not?
no,
Be given
yes, my prayer is only to inquire the matter. After that, due opportunity may be given by the end of irrigation department. If my lord,
Go there. That's under the criminal law. There is already a provision.
he has filed a PIL, my lord. It's a
no, this is
Interest
PIL.
litigation.
Yes,
No, sir. How public interest litigation lies in this case?
because my lord,
Let us see your averment.
yes. By producing fake certificate, they are got the employment and taking the money of from the state exchequer, my lord.
Only
Like the settled position that if a fraud and fake certificate and giving taking employment, it will visit everything, my lord. 13, how it prima facie seems that is a fake. Page number 13, date of birth is recorded 65 and date of leaving school is 84. That means 19 years old and he is reading at 9th class. 19 years old.
Prohibition.
Yes,
And
Any
again,
po-
no,
Nine-
just 1 minute.
19
Years old,
age of reading in 9th class.
9th class.
Yes,
So possible.
possible. My lordship, and second one, page number 18, date of birth is 70, left the school 92, age is 22 years, reading in 5th class.
So what is the difficulty? But there are many reports we find from the newspapers that even at the age of 60, 80s, somebody wanted to pursue because he could not pursue his studies because of some problem. Now he wanted. He appeared in a class 10 examination, passed out the class 10 examination at the age of 70s.
All the
in
It is a
1990s,
difficult.
all the applicants,
Mr.
all the
One news
employees.
that the daughter and the mother both sat for the class 10 exam.
It is not only the coincidence, my lord. All the employees are in 18.
In 1990s, in which class were you? In school, must be in school.
Yes, 8th class.
You are not aware. Odisha government had a policy of adult education.
Adult
And-
education not there.
Odisha government was engaging
Yes,
10th class pass students to teach them in the evening.
but
Are
not
you
in the regular
Are
school.
you
My
aware
lord.
of that or not?
Yes, my lord.
Then that was.
But they are not in the regular school, my lord.
Then the year which you are referring to,
Yes,
that relates to that.
no, but they are not in regular school, my lord. That is a separate provision.
Sir,
Yes, my lord.
regular school, is there any prohibition? So us from guidelines of.
No, it is not a
Don't
special.
say that he is 22, can't read in class 5, he is 19, cannot read in class 8. Don't say so.
Yes, my lord.
Which has no foundation.
Yes, but
We
headmaster.
appreciate that if there is some fake certificates are used
Yes,
to get the employment, definitely it is a duty of the employer to inquire into the matter and then take it.
yes,
You have already approached, you have filed an FIR.
yes.
Criminal
It is not
investigation
registered.
is going on.
It is not registered.
Let the I have seen election 5 series. Several authorities have already written to the headmaster that you can please certify. So the process has been initiated. It's not that it is not initiated.
No, only superintendent engineering has written, my lord.
No, many.
No, that is a
many, sir.
no, copy of that application has forward to the many.
So whatever I have
Yes.
seen in election 5 series.
Yes, my lord.
So
That is a letter issued by the superintendent engineer, Nimapada Irrigation Division, and copied to other authorities.
sir, this is the office of the superintendent engineer is writing to a headmaster.
Yes,
And then thereafter, irrigation department, sorry, the same is there.
yes.
Uh,
Copy forward to assistant engineer and junior assistant.
no, all are addressed to you have given 5 copies.
Yes, that is the
And,
respective.
There was another letter.
That is a respective headmasters, my lord. Because the employers are obtained the certificates from various schools. Yes.
What is that? Nothing. There. Take care of this. Bring it. We are not keeping this matter alive.
Yes.
The instant repetition in the nature. rejected.
Please.
Item 2.
Making an allegation against the person, not impleading him apart.
Sir, in school, certain records are destroyed in super cyclone.
That is what I
That is
said.
their contention, my lord.
Who was the headmaster? Has he disclosed? Has he disclosed that the signature is not of that headmaster? Nothing. Let them go.
Yes.
Simply saying that it has not been issued will not do. Yes.
Item 2.
Please, my lord.
Item 2, my lords, on behalf of Mr. Prafulla Kumar Ratha, I am appearing. His mother passed away yesterday, so I am seeking for a short adjournment, 2 weeks adjournment. my lords.
The-
Any day,
an
December.
application is sought on behalf of the senior on the ground of a bereavement. Yes.
My lord, 3, I think, has engaged my lord in 2 previous writ applications, my lord. I'm passing on the orders. I have something to apologize for, my lord. My learned briefing counsel. There's a faux pas that has been committed by us.
What?
My lord, page 35, 31, my lord may see what has happened. The prayer is incomplete. I may be permitted to add that paragraph, page 31, and then repaginate it.
Is this? Where is
It-
how the defect has been pointed out?
No, that is the sad part. It's not pointed out. I saw it, my lord. I was surprised. The matter was listed.
Original copy to the
I saw the original copy, my lord. It's in the net. Doesn't show that page. And
Sometimes
it's surprising it has missed.
these people
No, our mistake
scanning
is
it.
first. My lord, our mistake is first. Second mistake is the stamp reporter. Page 31, my lord, may kindly see.
Yes.
It abruptly ends.
We note that though the stamp reporter has not take out an application for amendment. That's why liberty is granted to you to.
I am obliged.
Item number 4.
May I please your lordship? Annexure 1,
All the stamp reporter was there doing.
may I please your lordship? The annexure 1, termination letter, as well as the annexure 2, tender call notice is under challenge. Now the previous,
This is also challenged
yes, my lord.
after participation.
No. Tender call fixed to Monday. Last date of is Monday,
Termination, you say.
my lord. After my termination, they call for the another tender call notice, which is last date is fixed to Monday, my lord. Annexure 1, page 17 is my termination letter. And annexure 2 is the fresh tender call notice, my lord. I bring your lordship kind attention the annexure 3, my lord.
Yes.
The previous tender, page
Yes,
20,
yes.
my lord.
Where is the agreement?
My lord, page 28, my lord. Page 28. My two vehicles,
Where
they are,
where is the termination clause?
and there is no termination clause, my lord.
Let us
Rather,
see.
rather
Let us
clause
see.
is there, my lord.
Let
Clause
us
7, my lord.
Clause 6.
This is valid up to 31st November.
My lord.
So it's still there.
No,
It's a 31st November will it come?
Yes, my lord.
Indian content.
This week will be flat okay. this kind of a contract is hit by section 14 of the specific relief act.
Well, the
And-
kindly
And also, in concern with section 73
my lord.
and 74 of the contract.
What happened in this
of a
case, my lord?
contract act.
My lord, what happened in this
Why
case?
not? Why not?
Your
you
lordship,
say that?
kindly see the previous tender, page
We can-
22.
We are not concerned with this. We are concerned with this, whether this, you are challenging their action of terminating the contract.
My lord,
This is a contract relating to a personal services or a relation to a providing a service.
my lord.
First thing is section 14 prohibits these contracts specifically enforceable. If the civil court is unable or denuded of power to specifically enforce, why the writ court will interfere?
My lord,
Second,
my lord.
if and these kind of contracts are determinable in nature, even if there is no clause for determination, it is implied inbuilt into it.
My lord.
And 73 talks about a compensation you can claim.
What happened in this case, my lord? But law is well settled that the tender court condition of the tender court notice they cannot modify. Lordship, kindly page
I'm
22.
asking you, when the tender is floated,
My lord,
then it is a freedom of author of the tender document to impose any conditions at
My
the very house. You can't say that you cannot impose.
my lord,
Only
I
challenge
agree, my
is
lord. I am
that it is unreasonable, irrational, malafide, or against any statute.
my lord. I bow down, my lord. Lordship, kindly see page 22 for a moment. Page 22, my lord.
It can't be done.
Page 22, my lord.
It's a determinable in nature.
Page 22, page para 12, my lord, point 12, my lord. Page 22, my lord. Clause 12. Period of contract is from the date of agreement till 22/11/2026. They cannot modify the conditions fixed by the authority, my lord.
What?
And after putting the tender in the completion of work order, they cannot change the condition imposed by them. I am not
This is a
disputing.
fresh tender, sir. This is a fresh.
No. This is the earlier tender, my lord. I am
What
placing
earlier tender?
in which I get the work order, which they violated their own condition.
This is a fresh tender.
My lord,
they have floated
my lord,
to invite the quotation because they have terminated your contract. Now they cannot remain silent. They wanted to have the hiring
my
of
lord.
those the vehicles. So they have floated a tender.
But they cannot change their own condition imposed by them.
Conditions.
The page clause 12, my lord. Kindly see.
Illiterate person.
Yes, my lord.
You are
Yes,
illiterate
my lord.
person.
I am studying.
Illiterate person.
I am studying class 5. I put my
Sir,
signature
I am
on here.
asking you, have you not put your signature? Did you put your signature in the agreement with the closed eyes? Did you not know what are the terms and conditions of the agreement? Are you not capable to enter into an agreement? Illiterate.
Yes, my lord. That is my contention. But they have.
Sir, I have decided in one matter
my lord.
relating to a loan where the same plea was sought to be taken, that I have taken a loan. I have held that you cannot take a plea that you signed with the blind eyes, sign the document without reading it. It is inconceivable, improbable when you have a capacity to enter into a contract. When you enter into the agreement, Did you not notice that the period of contract is reduced to 30? That's a wrong word which is used.
Yes, madam.
November cannot have 31st days. November has 30th days.
My lord. Then,
Correct.
my lord.
So I do not want to say anything, but you signed on the agreement.
But it is not mentioned.
You knew it that it is up to 30th of, or what is the last day of November?
As far my understanding is concerned, I am studying this class 5. I put the signature
Sir, I
notice.
have here, that's why I am saying if you can put your signature, if you have studied, you cannot sign without reading.
But this
You are
happened in
not
this
a
case,
rustic
madam.
villager who has put the thumb
This
impression,
happened in this case because they
nor a Pardanasi lady.
no, not like that. But even if Pardhanasini ladies also put the signature of reading, and it is not mentioned in the agreement that the contents of the agreement is read over and explained to me in Odia. But my understand, the agreement should be for 2 years. That is the reason I purchased new vehicle on loan. I am not unable to.
Sir, when you are going and purchasing a vehicle, are you not checking the vehicles that what is this? Don't you have a knowledge?
I have impression that these are 2 year, madam.
Your agreement, and these agreements are terminable in nature, not specifically enforceable under section 14. We cannot enter into. Now they have floated a new tender.
Yes, madam.
That's all.
But illegally they terminated me and giving a wrong date as per the local condition, madam.
You can go for a compensation. You can't claim anything more.
Because
all agreements are terminable in nature. I can remind you of the Hindustan Hindustan Petroleum case.
But it is their laches, madam. For there I am suffering.
When they terminated the agency, plea was that it can't be done. This has been done in violation. The court has said nothing doing. Is terminable in nature. If it is terminated, you are entitled to damages on.
Because from their laches, I am suffering.
No, sir.
Yes, that is clearly mentioned.
The reason is very alarming, sir.
No, sir.
You may deny, but the reason is very alarming.
Because I am illiterate person, and
Sir,
without going to the date of the agreement,
so
as per the terms condition of the tender call notice, they cannot modify. That is the law.
There is no modification.
Yes, madam.
What you are doing? You were working under the contract.
But if tender
The tender call notice was in English.
Madam?
The tender call notice was in English.
Yes, madam.
How you participated without reading the tender?
You could know that it is for 2 years.
Yes, madam.
But while entering into agreement, that was in English. You could not read that it is up to 2020.
But they have to explain me.
Oh, sure.
Or unless and until I know, just they put my signature.
Class 5, numerals of English you could not know.
No,
that is very surprising.
But as well, tender call notice for 2 years. And they are put that take my signature without explaining anything.
The tender was put it for
Arrear due kindly be considered, my lord. Page 16 I have mentioned.
Approach them.
Let's see, in this material, let's see, I have challenged annexure 4, that is the assessment order under section 62 for non-filing of return. But subsequently, the petitioner has filed the return and assessed under, as per scrutiny assessment, let's see, that is under annexure 2. Already for the entire year, it has been assessed. But that overlapping period is assessment order is still in that assessment order under annexure 4, it's still pending, let's see. That needs to be
The
withdrawn.
further assessment has already been done. He has been, she has been, or he has been allowed to file the return. You have assessed. You have passed the assessment order. How can there be a two assessment order?
I'll take instruction in this regard, but Glaxo comes into play.
Oh, whatever.
Because that
It's not a
2000, the
challenge.
impugned order is your
It's not a challenge.
challenge, your lordship. Impugned order is annexure 4 is
It's
of
not an impugned order. This impugned order actually is in no existence.
your lordship. Impugned
Infractions.
order. Why it is your lordship? Why there is doubt in the impugned order? There was a demand of 54 lakhs. Your lordship, in the subsequent order, I have to take instruction. In the subsequent order, the demand is 37 lakhs. Your lordship, even including a penalty. In the first order, there was no penalty, and in the subsequent year,
You don't get swayed by the numerical numbers.
no, your lordship. I'm not.
You are being swayed by the numerical numbers.
I just want to point out.
Now,
I
the
just
question
point out there
that-
might be some
that
difference.
He was not permitted to file the return. The order came to be passed. Subsequently, you permitted him to file a return. Whatever. Now, the assessing officer has given them an opportunity. Now, the assessing officer has passed the order of assessment in respect of a same financial year.
Entire year, your
Same financial year.
Yeah.
Your lordship.
If that being the position, how can the two orders for the same financial year operate? If the latter order has come, that it presupposes that the earlier order has.
Your lordship, I have to. I'll take instruction.
So this is what we say. Don't Glaxokill. This is something different.
Your lordship, something different. Your lordship, only
There is a
I have to
if
take
there is
instruction.
there is a manifest error. Can we not?
As your lordship, please, sir.
It is. Fine.
As your lordship, please.
No,
I'm
no,
not-
Can you show me the subsequent order?
Your lordship,
take
let
the
me take
annexure
instruction. Your
2.
lordship.
Annexure
Let me
2.
take instruction.
Annexure?
2. Page 14.
This is another assessment. This is a GST assessment here.
Same. For
So 62
this
is
62.
to be non-filer.
Yes.
Yes.
And that is for
non-filer.
non-filer for 1 month.
Return.
Yes.
So the
Entire
now 73 has
the proceeding has
come
been and already
on the basis of that returns.
entire year.
Returns were taken care.
Yes.
And then the
After
assessment
that,
order is passed.
after that,
That I have to take instruction.
This
after
is
that,
what annexure 2 comes.
That I have to take instruction. Your lordship.
Really?
I'm sorry. I may be
after that
permitted.
appeal also filed.
I may be
I
permitted.
have also filed appeal, that is annexure 3,
See, to be very
and that is appeal is
pragmatic
pending.
in this,
Your lordship.
No, sir. These are the documents you can't
That is
deny.
for 1 month. Your lordship, the past 62 order is for 1 month of March.
Yes.
Your lordship, this is for the entire period. Your lordship, I don't
so
dispute
you
that.
adjust
So that
I don't dispute that.
that is
Only a small instruction. Whether that
Sir, I am talking about if you talk about a particular month, but later on it is which covers the whole of the period. Then in
it is fine.
when you're talking about can you
Your lordship,
segregate the month?
only a week's time.
What?
Only 3 days time. Your lordship. Only Monday or Tuesday. Your
Tax
lordship.
period is from April to March 2022-23, and both CGST which covers this
Only state tax. Only state.
both.
Both. Yes.
63 last
CGST and SGST
Yes.
both.
Yes.
I have seen page 15. That's why I'm
Yes.
saying.
Yes, sir. And
This
annexure.
is in relation to only the
One.
March 2023.
Yes, sir.
So it covers,
Yes.
covered into it.
Your lordship, I'm not in dispute. Your lordship. Only one because
Then-
also
then-
recovery
then
is not.
Don't take time.
Also, recovery is not there. Also, we have not done any recovery. What is the status, your lordship? Let me tell only 2
Appeals.
days.
It has status is it remained on the record. I'm telling you. The status is remained on the record.
is pending.
Everyone says that it should not remain on the record.
Obliged.
That is Had you withdrawn this order by virtue of a subsequent order, she should not have come.
In 73, you should have said that 62 merges here.
Yes.
Your Lordship, even in 62, there is a rider that within 1 month, if subsequent return has been filed, then also that will be dropped. I don't dispute. I'm well aware about Your Lordship. I'm not disputing that. Only a
Sir,
short
you have
instruction.
to allow conduct of business, then you get the taxes.
Can't. Yes. Sir. If there is any other facts which they have said is wrong, if it comes, tell us. We'll see to it.
As Your Lordship.
Obliged.
Yes. All this thereafter. All the next ones.
Item 7.
Yes, my lord, my pleasure. Just I am challenging the annexer 8, which has been outrightly rejected on my appeal on the only ground is bar by limitation.
So what can be done, sir?
Sir, please remand the quasi-order, remand for reconciliation. Because the registration certificate cancelled during the pandemic.
If the outer limit set forth therein
Yes.
has expired, can an authority go beyond it?
No. No,
Can
no.
the writ court go tell him to do something which is forbidden in law? How can
No,
we do it?
Only prior to reconsider the because the cancellation has been made within the during the pandemic period. Pandemic period within 10 days. First so-called notice on 5 to 2020 and rejection was 15 to 2020. Then during pandemic could not able to know about the rejection order. Then
Your Lordship, he has a case, but his prayer and his party both are defective, Your Lordship. I'm very sorry to point out. What is prayer? That prayer may not be allowed, but he can get relief in other ways. Your Lordship, Your Lordship may kindly turn to the prayer. Page 12.
Sir, we are bound by our own judgment, sir.
sir,
What
my
can be done?
limited prayer is only to for reconciliation. The matter may be remanded for reconciliation only because I have suffered during pandemic.
Not so easy, sir. There are many legal hurdles.
I know.
Many legal hurdles. We can't.
I know, sir. My liberal view may taken and
Let him. No, Your Lordship, let him amend the prayer and let him make the proper officer as party. Then Your Lordship can allow. I'm well.
I have met the party who was rejected my appeal. The joint commissioner.
Since there is no provision for
Your Lordship knows that delay is coming.
No,
Being the statutory authority.
No, Kuomoto revision, there is no limitation which is
No, so much revision there is no. Your Lordship.
There are. I was referring to my brother. There are some.
Your Lordship, all are not interested, na. How can it be?
Power. The Sumoto power was there. That provision contains that two modes of this. One is a Sumoto, another is for the application of the
Your Lordship.
For the application of the parties, there was a limitation.
Your Lordship.
Application was paid. The rejection came which was challenged. State took a view that since it is application for revision, so period of limitation rightly done.
Well,
The view of the Calcutta High Court was that no, was simply an information to the other
Your Lordship.
to exercise the power of Sumoto. He did not apply a power revision. He just gave them an information so that he can exercise.
Your
As Sumoto, he can exercise.
Lordship. Only
Here
difficult.
also, some merit has been given that there is a glaring illegality.
No, glaring illegality is not there. Your Lordship, he has not filed the return. His cancer registration has been cancelled. So it can be restored. It can be restored. I am not on the way. I have rectified.
I have filed.
I have already modified that order.
Only I have filed the return annexer 2 series my return. Thereafter,
The only fact is that he has to make the proper officer as party because proper officer has to take care of the registration. Neither he has made the party.
We are the better.
Grateful, Your Lordship. I am also Your Lordship.
Registration cancellation. Yes. Allowed.
yes. Yes, matter.
One. Item 8. Item 8.
May I please? This is a matter relating to a education trust matter. In the education trust, there is a 12 registration certificate is there.
Yes.
12 registration certificate is there, basing on which the return of the trust have to be considered under section 11. So that whatever expenditure they have claimed, it has to be allowed. So here is the case in the assessment order itself. Your Lordship can have a glance to annexure 13. That is assessment. Well, here is the case. Well, appeal provision is very much there, my lord. Here is the glaring mistake is there, my lord. 246 says appeal. Under section 246 appeal, but why we are not going to appeal? Because
the appellate authority prevented from deciding this issue.
and it is the mistake glaring itself in the assessment order, basing on which the assessment order cannot be passed.
Correct the mistake.
In the appeal provision, my lord,
There is a provision in the statute where you can correct the mistake.
My lord,
There is a
my
ministerial
lord,
mistake, numerical mistake, arithmetical mistake that can be corrected by the
my lord, here is the mistake. It is a very much a glaring mistake as because I have already approached. I have already approached. They have rejected it.
Reject. Now, is there
We are coming before my lords.
a revision or appeal against that order?
My lord, your lords, we can glance only page 96. Your lords, have a glance. Page 96. Here is mentioning that the date of rejection approval on 17/9/2023. It is assessment year 23-24. It is meant for 24-25. Basing on they made an assessment. Because in that year I have a valid license. My lord, in going for appeal to pay 20% of tax.
Can you avoid this is the
No, no.
forum to avoid the statutory
My lord.
obligations.
When there is a
And exempt from paying payment of tax during the pendency of there is no requirement of paid upon.
if
Is it compulsory? If it traces the assessment of the fee,
It can exhaust.
my lord, department has violated his own circular. His own circular is immediate circular. So there is a.
This is the argument, but advance before the object.
Well, I have already submitted 154 application stating that those facts. So whereas my 12 certificate very much in substance, why you make assessment? Circular is binding on the authority.
Stop entertaining the
My lord,
is our discussion if there is an teacher's argument. We do not want to exercise the risk.
no, when the jurisdiction point is there, they cannot pass the order.
Of jurisdiction. It's not a question of jurisdiction.
My lord, when
It was competent, it's a wrong. If he has wrongly decided anything, then he can get it corrected.
my lord, if they are knowingly making the wrong,
No.
when my registration certificate is valid,
To assess the
my lord,
we are unable to assess what is passing in this month.
my lord, when
So straight face, we are unable to comprehend what is passing.
man, only let's become a glance page 96 for a moment. Page 96, so let's have a glance. Here is here.
Say we will definitely will not shackle.
Man, where is the mention is that in that period my license there. He said that your license not there. For which you making assessment. How it is so?
But no, this is a mistake. He has said it's not a mistake.
I have already pointed out in 154 application. But rather they have rejected saying that it is not a primary mistake. Then what do we have to do? We have already application 154 before the authority. My 12 certificate very much is there and it is not covered under the violation of possibility circular. Then how can pass order? But they say that it is not a mistake apparent on the record. Let me take instruction, my friend. This is how they pass such type of order. Honorable Apex Court and the full bench have already decided that circular is binding 100% before the authority who has passed the order. When the very much circular is there, how they can pass order? They himself passed circular, they himself violated circular.
Yes. So
Man, let me take instruction. This is how they pass this type of order. When the circular is there, it is binding on the department. They'll take instruction.
Other instruction.
They take instruction how they pass this type of order. Clear violation of their own circular. CBD is a pass circular. It is binding on the authority. The Supreme on that very point.
Opportunity granted through VC, my lord. So I pray for one more opportunity since the taxable limit is below the service tax limit as per the notification 33. It is on 10 lakh. Taxable limit exceed 10 lakh, then service tax is payable. But here the limit is only 3 lakhs some.
What is it?
No, my lords, personal hearing, so cause notice was served. They appeared and filed the documents. And in personal hearing also was given, and they have
Only
appeared.
one opportunity.
During the peak of
COVID.
My lords, what I am humbly submitting that
you did not get the notice.
No further notice granted, my lord. Only one notice. And
No. How could you come to know about this order?
thereafter, my lord, attachment proceeding.
Attachment.
Yes, ma'am.
When was it?
In the 24, my lord, for us.
24.
Yes.
Then immediately you didn't approach.
Thereafter, no notice, further notice issued, my lord. Hearing.
Once attachment notice was given to you.
Then you came to know that this order of assessment has been passed.
Yes, my lord.
So did you immediately challenge that order?
No, my lord.
Why you were doing sitting tight over the gun? 2024.
In 25, I filed the writ petition already.
Now, there is a limitation period for that.
Yes, my lord.
I
Limitation.
can understand that limitation will be waived because of the COVID and
COVID.
the Supreme Court judgment which is there.
Yes, my lord.
So
They have appeared in courts of assessment also, and they have filed the documents. All the documents were taken into consideration.
sir, participation in the assessment process and the communication of the order are two different things. If you did not communicate the order to them, he says that I was not aware of any such order has been passed. It came to my notice only when the attachment notice was served on.
Yes, ma'am.
So that we can visualize that these situations may arise. You have to communicate the order.
But as it seems, this is not the original order which you have received.
Got the order from the office and filed.
Office.
Yes, ma'am.
Only a copy of the order you received.
Yes, ma'am.
So kindly see page 25. Forward. Page 25. In a tabular form, the assessing officer has considered this
But will you not communicate the order to him? Will you not?
The appealable order and the entire commission has been considered by the
47,000 rupees is
yes.
So
47,000.
So from where you got this figure? What you say that it is not reaching the
Limit of
taxable limit.
No, my lord, turnover my
Threshold limit. What is the threshold?
10 lakhs, my lord.
Threshold limit is
10 lakhs.
10 lakhs.
Yes, my lord.
But the my lord, the gross is during the year, my lord, may kindly see.
My lord,
44 lakhs. 4 crore 46 lakhs.
I understand, sir. In second order, you have already dropped so far as 64 lakhs are concerned.
Based on their document.
True.
Only regarding
You
this
say that you cannot, but 47,000.
3 lakh 24,000, the documentary evidence of this
No.
receipt, they have not.
No opportunity granted, subsequent notice not granted, my lord.
The order. What is this?
Similar year, my lord, remanded matter to the for opportunity, further opportunity.
That is different.
No.
That is different. There actually the note order was
Compassion, asking for mercy.
but their expertise order was passed.
What is the class of contract?
No,
Special class, A class, B class, or
perhaps A class.
perhaps
No.
you working with your client.
Contract of 47,000. In this case, which my learned friend is citing, there the expertise order was passed, but here he has participated, and all the documents has been considered. This order by
47,000. Why you are fighting?
No, penalty also 47,000. Both penalty 47, tax 47, and interest also 30,000. Interest also imposed 30,000. So penalty may be waived. So
1 lakh something.
Yes, my lord.
Right.
But
You are a class
not
one
exceeding.
You are a class 1 contractor.
But not exceeding the taxable limit as per the notification, my lord.
Yeah.
More than 4.5 crores turnover. Maybe they might be.
But it is not legible tax, my lord.
Revenue has suffered for last 5 years.
But
without getting it recovered.
But it is not legible tax, my lord. It is violating the circular notification.
The show cause was issued in the year
And
2000.
No, only one date, only one note opportunity granted, and through BC, and thereafter no subsequent notice for confrontation of the matter regarding that 33 lakhs.
Just mega exemption notification is in your favor.
It is my in favor that dropped the subsequent notification 33 2012, which is that 10 lakhs is the limit for above 10 lakhs, the service tax is levied.
Try your luck.
You definitely rejected on
Or
the.
else, for delay and laches, you will lose.
I'll go for appeal for.
Or you are sitting tight over the matter. This considerable day. Nothing. Yes.
What do you want?
Appeal.
Appeal.
Go for appeal.
Challenging the assessment of wicked so and so. Just go to.
Item 10.
Item number 10, challenging the order passed against the 734B of the Finance Act.
Item 11.
Item 11 is consolidation of multiple financial years in one single show cause notice.
Here is appearing. I submit one thing in a recent development. Honorable Appeals Court has upheld the judgment of Delhi High Court in the very same matter.
And in that case, what my learned friend is submitting, that is the case of availment of fraudulent ITC. That was the fact before the Honorable Apex Court, where the Honorable Apex Court has held that as that interlinked periods, therefore allowed the multiple tax. It is with regard to
let this purpose be considered. There cannot be backwards. That's true. What the combination of fraudulent? No, speaks. Fraudulent.
Cases have been
Minus.
Let us
pending.
let us tag with that. Give the numbers. We'll decide on this. Keep it in the table.
Multiple.
We just keep it. Keep this matter in the first week of December. All the matters will be decided, including this one. Yes. Yes.
That is to be disable.
Item 12.
This matter relates to section 73(4)B. Yes.
13.
Item 13.
15 minutes. This is regarding GST RC cancellation. RC cancellation.
Yes. Both.
Both the matters.
Item 14. I shall Portugal for absent cancellation.
Yes.
Next. Item 15.
Relating to 74 man.
17-4. 74.
Yes, ma'am.
Item 15, read copy. Sir, item 14 लिख दो.
Yes.
Item number 16.
May I please, Lordship? Just before giving my brief, Lordship, just I want to give a small impression, Lordship. Let's kindly see.
Well, it's in item 15. I have not received the copy, read copy.
Please give a.
That's why
I have given my lord another example, my
Please.
Yes, my lord. Yes.
Lordship, just the 2-page document, Lordship.
This is document 2 page.
Lordship, I am the best performer of the state, Lordship. This chairperson is the best performer of the state and has been given award. Lordship, kindly see the next page. Yes, Lordship. The chief minister, chief secretary, minister, all have given Lordship awarded me as the best performer of the state and have awarded 3 crores rupees for my development my council, Lordship. So then, Lordship, I will come to the brief, Lordship. Lordship, here there is a provision under section.
This is.
Lordship, there is, no, sorry, Lordship.
For the other side.
Lordship, state, Lordship. State.
What is this photograph? Hey,
please.
This photograph.
No. We are giving original.
Let's
give it.
Let's go.
Yes.
Let's kindly come to section 53 of the Act. There is a arbitrary provision under the Act, Lordship.
Arbitrary provision?
Yes, Lordship. Without Lordship, because that's why I am correlating this photograph and Lordship their action. Lordship, once they are giving me best performer of the state and they are utilizing the section 53, issuing a notice for dismissal. Lordship, I am the best one. Lordship, kindly section
best Pradhan.
Lordship, kindly section 53 for a moment, Lordship.
Panchayat.
Lordship, Orissa Municipality Act, Lordship, here.
Municipality.
Section 53, Lordship.
Yeah. What is the judgment of the trial court?
Lordship, here Honorable Single Judge Lordship has remanded a matter. Lordship, when there is a lacuna, there is non-compliance of the statutory provisions, Lordship, there is a strong infraction. Once again, Honorable Single Judge is sending me matter. Please rectify it and take action. So, can it be curable, Lordship? That is my whole question before Lordship. If that is curable, then I don't have any case, Lordship. Section 53, Lordship.
Yes.
Section 53.
Corporation
53 of the Act.
Municipal Act.
What's a Municipal Act, Lordship? 1950.
Corporation.
I have quoted the provision in page 8, its Lordship. In my writ application, that provision is there. May I read, Lordship? If at any time during the term of the chairperson or a vice chairperson, it comes to the notice of the state government that such a vice chairperson
Case of any allegations being made against you for your removal, or it's a case of no confidence?
No, sir. Lordship, there is allegations on instructions, Lordship. That is, if comes to the notice, Lordship.
Then Lordship kindly see there perhaps this particular provision, Lordship can there speaks of perhaps Lordship 3 ingredients so far the 53(1) is concerned, Lordship. There must be a willful or Lordship, omittance, Lordship, willful omits or refuses to carry out or to disobey, Lordship, or in non-compliance of the statutory provisions, then they will have an inquiry, Lordship, by their own collector, district magistrate, or director. Then, Lordship, section 2 comes, Lordship, subclause 2. On receipt of report from the inquiring officer, the state government shall have an opportunity to the concerned person or vice chairperson to submit his explanation with period of 3 weeks through the inquiring officer. Then 3, Lordship, the state government, after considering the report of the explanation together with comments, if any of the inquiring officer and on being satisfied, chairperson of the vice chairperson has failed to discharge the duty of office or has acted illegally or in contravention of any of the provisions of this act or any rules, regulations or bylaws, shall be notification issued as per the practice. Page 6, 56, Lordship, Annexure 1. Page 56, Annexure 1. Lordship, this order is complete, Lordship, section 53. If at all there must be, if there is a knowledge of the state government, it has to be inquired into by the district magistrate or director. In absence of the inquiry report, the issuance of section 53, Lordship, section 53 cannot come to play, Lordship, to the picture. So, Lordship, kindly there contains section 56, Annexure 1, Lordship, another writ application, page 56 of my brief. Without any inquiry of any officer, Lordship, they have not come to make an inquiry. Straight away to the exchange section 53 and have issued notice for removal, granting me 21 days time, Lordship. So that was the subject matter of the writ application. And Lordship, that is, Lordship, Lordship. So, Lordship, section, they have non-compliant section 53(1), Lordship, kindly come to, I want to read out, Lordship, the entire.
I've already read.
Lordship, grateful, Lordship. So, without, Lordship, any inquiry report, can they, Lordship? So, Lordship, definitely they contact to the statutory provisions. If at all, Lordship, they will proceed, then also, Lordship, I can explain, Lordship, 1, 2, the 3, that 3 allegations are not against this chairperson, Lordship. Both section 63, section 7 and 2, and the Lordship, the development works, it is never coming to the Lordship domain of the chairperson. 3 provisions I can explain, Lordship, section 63(1). Lordship, I will come to section 63, Lordship, for a moment. It's Lordship, conduct of business. It is, Lordship, ordinary proceedings, Lordship. Section 63. The councillors shall meet for the transaction of the business at their office or at some other convenient place.
One observation.
Grateful.
The authorities have not taken any final decision, simply issued a notice. You came and challenged them. Whether the ingredients of those allegations are in tune with the sections or not, it is the authority who has to decide. She has not taken any decision as yet.
Lordship.
So we will not enter into that intricacies, whether the allegations are correct, allegations are in tune Whether those are false allegations, it is the authority who has to decide.
But Lordship, had it been a case notice under section 53(1),
Yeah.
I don't have any grievance, Lordship.
We are saying so.
Lordship, one thing, Lordship. If had it been a notice under section 53(1), I don't have any grievance, Lordship. It is a notice under section 53(2). So, Lordship, enter consideration, Lordship, enter, Lordship, it only comes to disqualification.
Yes.
Lordship, I see page 80, my lord.
Perhaps I'm not convinced you properly, Lordship. Perhaps I've mistaken my submissions, perhaps not properly, Lordship. Appreciate, Lordship. Lordship, kindly see 53(1). 53(1), Lordship, I don't have any grievance. It is a not notice under 53(1). It is a notice under 53(2) for disqualification. They will, Lordship, they will state that they'll give the disqualification. 53(1) speaks, Lordship. Lordship, perhaps Lordship not properly convinced, Lordship, perhaps.
Probably we are stuck with the nuances of law more.
Perhaps.
Please, let us explain that
Lordship.
53(1) and 2 says.
Lordship.
53(1) does not talk about any notice to be issued upon you.
Grateful, Lordship. Grateful, Lordship.
It simply talks
Lordship.
when anything has been informed, an inquiry has to be conducted.
Lordship.
And thereafter, the state government may take an action.
Lordship.
The district magistrate
Lord.
take action as may be directed. 2 says that before you take any decision, an opportunity of hearing or opportunity to explain, that must be afforded to a particular vice chairman or chairman.
But Lordship,
you cannot proceed without seeking for explanation.
Lordship.
To ensure the principle of natural
Lordship.
And thereafter, 3 says that what decision you can take.
Lordship.
That's the only thing.
No, but my humble submission before, Lordship, 53 to come to play in absence of 53(1), Lordship.
Oof, say.
So, Lordship, Lordship, please, Lordship, 1 minute, Lordship. Perhaps I am not properly convinced.
Then the wheel of.
No, Lordship, perhaps it is great issue, Lordship. Kindly see, Lordship.
So we are saying that what is there and what has been directed, we are simply making some clarification.
Lordship, 1 minute.
Some clarification.
Lordship, clarification will be, Lordship, it will suffice. But Lordship, kindly 1 minute, Lordship. Lordship, it is time there, Lordship.
There are others who are waiting.
But my case is very urgent, Lordship. Because
we are saying,
Lordship, 50.
Let us hear that what we say. This is what we find. When you argue, then again I say, argue will not prevent you.
I'm not arguing, Lord. I'm making Lordship.
That's why I'm saying you are arguing. We are saying that we have seen this. We have seen the release which has been given. Only thing is, something should come first.
Lordship.
And one should go later. We are just uttering the reliefs granted to you.
But that's true, Lordship. Lordship, I got the point, Lordship. I am convinced. Lordship, I am happy, Lordship, with that on. But Lordship, my humble submission, can it be rectified, Lordship? The only thing, Lordship, I am challenging the order of the Honorable Single Judge on the ground that can it be rectified, Lordship? So, Lordship, it can be examined, Lordship, absolutely correct. Let them examine, Lordship. But it cannot be curable. It is not a curable defect. That is my whole submission, Lordship.
After perusal of the
Yes,
Nothing.
that's it, sir. Grateful,
Yes.
Lords.
Next.
Item 17.
Yesterday I mentioned
17.
item 22.
Your Lordship, for the motion that they issued a corrigendum, they have extended the last date of online tender online submission to 29/11, Your Lordship, and opening of the tender on 1st of December. And since they have come with all the documents, Your Lordship will prepare an affidavit and file it next.
What affidavit? 29/11.
My lord, this matter is what has happened, my lord. For the refreshment of this honorable court, I may be permitted to again submit, my lord. Yesterday, this matter was listed, and my lord has directed to come this matter today only. My lord, what has happened? Chief Engineer of Boitrani Basin has awarded me a tender for supply of manpower at Salandi Canal Division. Accordingly, directed Superintending Engineer to execute an agreement on 1st of July. This is the only instance. And Superintendent Engineer, without complying with that order, by defying it, has issued another tender on the self scope of the work, my lord.
Where is the bar?
My lord,
Where is the bar?
the bar is, my lord, there is a direction of the superior authority, my lord, to the subordinate.
Only thing is just to have the continuity of the services to be availed. They may have extended the time to continue, but
I have been declared a successful bidder, my lord. I have been awarded with this work. Without executing an agreement with me, my lord, Superintendent Engineer, he has floated another tender, my lord. Chief Engineer has already awarded me.
They were saying that he was asked to provide some documents. The documents were insufficient. He was asked to provide some documents, and for 3 to 4 months they waited. He didn't.
So will you not communicate that because of this?
Lordship, I've asked for all the documents. They have come, Your Lordship.
Then there is no imminent threat because 29th is far.
No, my lord.
Come on, next Wednesday.
My lord.
Sorry.
Item 18.
Item number 18, 1 week time may be granted to filing an affidavit, my lord.
Is the first extension?
Yes.
1 week. 1 week rejoinder, 2 weeks.
Item 19.
This is that matter, my lords. Yesterday it was placed that Indian Oil matter, replacement of 2 vehicles.
I have already, yesterday I have taken care of it.
My lord.
Don't worry, it will be. I could not find time because of your assignment.
My lord.
The case which is connected, my lord, that has come. Mr. Rath is appearing. Unfortunately, the mother died yesterday, my lord.
2 weeks.
That in that case, interim order is required.
They need an interim order there.
Because based on the cancellation, my lord.
Just come tomorrow. We'll see. I mean Monday.
Monday. Great.
Yes. What are the others?
Item 20, my lord. Trace application.
Withdraw.
In the applicant. In the applicant form. My lord, I will withdraw.
Give a memo.
I will give a memo. Your lordship may observe that the liberty to file a trace
Which I have, which Your Lordships have been produced for the weekend.
What?
Yesterday, the NGT matter, Your Lordship.
Okay. Yes.
Judgments I'm giving, Your Lordship.
So item 22 actually is urgent because examination will be held on 16th. Your Lordship therefore fixed the matter today. Yesterday actually the matter was there with Your Lordship. Copy was served. And
what is this 21? Who is this?
21. That's that promotion. Annual property inspector.
Oh.
Yes. That matter, my learned friend has filed a copy of the counter affidavit. Today they have brought me a copy.
Oh, that is all. Malady yesterday, Malady
last week.
Put it on next Thursday.
Malady, it will be Monday.
Item 22.
The 22 was an advertisement for recruitment of 6,000 odd teachers. 6,000 and odd teachers for recruitment.
6,000 and odd?
Teachers. But what happened? There are different faculties. One of the faculties is the Hindi subject.
There is a caveat. Have you served the caveat?
Yes, caveat's copy has been served. So this is only confined to the Hindi teachers' merit. If Your Lordship looks at the advertisement, is at page 36.
The single bench has rejected.
Sir, single judge actually said that the entire examination has been cancelled, and to redo the entire thing, so far as the Hindi teachers are concerned,
And that is the grievance of the petitioner who appeared with the examination.
No, I understand. Then re-examination has not been.
No, day after tomorrow it is there.
What?
Re-examination. 16th is
Let it have consider.
But Your Lordship may indicate on Monday if Your Lordship call this matter on Monday.
Order in that way. Let us see.
No, 16th, let the examination be held.
Let the examination come on Monday.
So 17th, Your Lordship may call this matter.
Subject to result.
Not so.
Was heard on 28/7/2025 that reserved for order. And I have made a mention of your lordship directly that to reserve.
Yes, you have to argue.
What matter? I pray for
Item number
28 we will
Monday.
or withdraw.
Monday.
No, 28 he says withdraw.
24.
24. Yes, come on, Monday.
Minor 25 the acceptance
That is subject to result.
of requisite. Requisite filed in late, acceptance of requisite.
25.
My lord.
Is,
The
yes.
22nd, the examination will be subject to result.
Be accepted. The office is directed to immediately take steps.
Subject to result.
The result of
Great.
One.
Pardon, my lord, item number 13. I pray, my lord, let it be taken up 1 week after.
39.
13, 1, 3, my lord.
1, 3. You have filed it, do it.
Mr.
Do it,
Ashok,
do it.
Mr. Ashok Das has filed this.
Anyhow, so he is not here.
Not here, my lord.
Yes. Take it in next week. Yes, call one.
Item 1. Yeah, not an application.
What is the challenge?
Rejection of a prayer for acceptance of additional evidence.
Additional evidence.
Order 41 Rule 27. In fact,
Before the appellate court.
Before the appellate court.
Can it be done in isolation or it has to be heard along with the
appeal? Along with the appeal. That is exactly my ground. Now it has been rejected without hearing the appeal. That too on the ground which was taken before the trial court for rejection of a amendment. That has been the reason why this application has been rejected here in appeal. And it cannot be on in isolation.
Was that judgment of the Supreme Court? Where is the other side? Then you'll have to issue a notice. Other side is here.
This honorable court's judgment is out.
Where is the other side?
A notice has not been issued.
Issue notice, short notice. You file the requisites today.
Yes.
File it today.
By tomorrow or by Monday, because it is already
by
late.
Monday. Returnable after 2 weeks.
I'm praying for stay of that appeal because he's proceeding with the appeal.
When is the next date fixed?
Pardon?
When is the next date fixed?
Next date I cannot ascertain, but
for early disposal of a missed case filed under Order 21 Rule 101.
The third party has come before the executing court.
My lord, I'm the decree. Lord, it was filed on. I've got the entire order sheet.
Number
17/9/2024. 24. My lord, because
whether you are a degree holder or
decree holder, my lord.
Decree.
No, my lord.
You have not filed an objection to Order 21 Rule 101 application.
We have only appeared in the case, and till then, my lord, since there are many parties.
Third party has fought for his right title and interest to be decided by the executing court. You have not filed your objection.
My lord, here the fact. No, my lord, here the fact is that
You chose.
No, my lord.
So let me direct. He could decide immediately. Doctrine on non-travelers.
No, my lord. No, because my lord, here, my lord, in the one.
Objection. You have not filed your objection to their application.
No, my lord, I have not filed. Since
this requisite to affect the service,
Repudiates.
Oh, somebody has died in the meantime.
My lord.
So, heirs have been substituted.
Heirs have not yet been substituted.
They are the degree holder, not the judgment letter.
Decree holder, my lord.
So,
My
I
lord.
don't know, it is separable degree or inseparable degree.
Inseparable.
Inseparable, then it must await as a whole.
But my lord, since it is a 21-101 petition, they have to go for.
So you are taking advantage of level that does not apply to execution today.
My lord. 101, my lord, says that you have to decide the right title interest. My lord.
From 121 to 97, 98, 99, and the 101.
Resistance to the decree.
So, but yes, why the substitution has not taken place there?
So it is at an ascent state, my lord. Lordship may indicate for disposal within 6 months, my lord. I only pay.
Without substitution,
Because my lord,
dead person. Are you sure about the law? Can it be proceeded against a dead person?
no.
Yeah?
My lord, here, my lord, in the present execution case,
About deceased opposite party number 7 substitution has already been carried out.
other, my lord,
Oh. 31/7/2025.
last.
And then the notice is directed to be issued against the substituted the party.
My lord, yes.
It has not matured for hearing.
No.
So, you are appealing for a degree holder, then you should appear for all of them. You have volunteers that you have instruction to appear for.
No, my lord, those were the pro forma dependents in the trial court. Maybe for the.
So, forma dependent in what? What? What was the suit for?
It was a suit for right title interest and eviction, my lord. And those defendants.
Section 5 of the suit degree back.
My lord.
Based on title.
Based on title, my lord.
Then why you put a pro forma difference?
Because
so semblance of right.
My lord, because they were in the possession as shop room, they were the tenants, my lord. Because another party against whom I had prayed in the suit, he had inducted these pro forma dependents as the tenants. They were running shop rooms.
They are the subtenants.
Subtenants.
And you make them a pro forma.
In the suit, my lord, it's a decree of year 2007. My lord?
Who will be evicted ultimately? Subtenant?
My lord.
You did not make them a pro forma. Who invites each other? What can be done? Sorry, this application under Article 247 of the Constitution.
May I please, Lordship. I am challenging the order dated 16/7/2020. Order to against the order, first appeal order, first appellate order
Against the injunction order, my against the injunction.
Order, injunction order.
Yes, madam. Civil court passed the injunction order, madam.
So against that, you prefer the first appeal.
I have not preferred. Defendant has preferred.
What?
Yes, madam.
Then
First appellate court has set aside the order of injunction.
set aside.
Yes, madam.
So you have come.
Yes, madam.
What is the reason? What is the suit for?
Suit for not specific relief act not to evict without following due procedure of law. I am tenant. Admittedly, I am tenant. I am a tenant, my lord.
You are a tenant.
Yes, madam.
So it says that you suit not to evict you without due process of law.
Yes.
And what the court did?
So
Passed an injunction?
Yes, madam.
Was it a final order or
no
interim order?
Interim order, madam. Interim order. Order 39.
Application under order 39 you want to is pending in the trial court.
No, that was disposal. That was order.
That is final order of temporary injunction.
I'm sorry, madam. Final order. That is final order.
Then why the appellate court reversed it? Why, on what ground?
Well, page 27, my lord. Only, my lord, only ground that I am tenant, have no right at interest.
Notice.
Yeah.
How it will be registered as ATU? I will register this proceeding. O means
Order against.
First appeal against order. First appeal against order.
So these are appeal under order 43 rule 1.
Yes.
That's why the asking for here miscellaneous appeal.
Yes.
That was
Regular first appeal.
earlier it was been registered as MA, miscellaneous appeal, but subsequently the nomenclature has been changed.
They are also accepted miscellaneous appeal in the district courts. And if it is directly coming under the High Court, then it is the FMVP, first miscellaneous.
Here the nomenclature.
You are not FA1.
Item 4.
I have filed a miscase, madam. Miscase I have filed. Miscase. Not to further, stay further pursuing, madam.
In an injunction matter, the stay of authority unknown.
Okay.
Either a order to be granted, but not stay. Injunction has nothing. Injunction is passed in aid of the final relief. Does not mean that the final relief should be stayed.
Okay.
Bad person.
Item number 4.
Yes, may I please, Your Lordship, the petitioner challenges the impugned order under Annex 3, that is, Order 39 Rule 1 and 2 petition has been rejected, dismissed, below. So I would like to draw your Lordship's attention. The present petitioner is the Sarpancha. The impugned order is.
Going to appeal.
Yes, no, my lord, this is the CMP file arising out of the suit order, my lord.
I'm asking you, sir, if certain orders are applicable in nature,
My lord.
can a CMP lies?
Yes, my lord, that is because it is an against an interlocutory order.
CMP lies, then section 104 of the CPC should be ignored. Order 43 of the CPC should be ignored. These are the two principles.
My lord, during pending adjudication of the civil suit, the IA filed for order 39.
Not only restricted to victims.
My lord.
Under the code of procedure, certain orders are also available. And this is one of them under order 43 rule 1 small r. So The opening word of order 43 good mornings and appeal shall lie from the following note.
Yes, you'll.
You have to go for an appeal, not contentious.
So, my lord, the factual background of the case is. No, my lord, just I would like to draw your lordship's attention.
Wrong forum. There are wrong forum merit. Suppose you have the best case on merit. In a forum which lacks jurisdiction, pass an order. I'm asking.
My lord, here a case, my lord, the president plaintiff filed a suit for a declaration of the right title and for to declare the alienation order as null and void, my lord. Whereas I would like to crave the indulgence of this honorable court, whereas petitioner is the Sarpanch of the Gram Panchayat and an administrative capacity, there was a 2 market complex, 110 rooms in the Gram Panchayat and public toilets are there, and the peoples, the SC/ST tribal peoples, they are running their business and earning their source of income. In the background of the case, the petitioner belongs to Raikia Gram Panchayat, she is the Sarpanch, and the property belongs to Gram Panchayat since 1940 as per Yadastha law. So pre-settlement, they are in possession of that property since 1940. Where is it? My lord.
Instant application.
The respondents earlier approached before this honorable court and they have filed PIL, my lord. That has been dismissed. Kindly lordship.
The assumption
Pending, my lord. So civil suit is pending for final adjudication. Just I am coming against the interim order, my lord, interlocutory order.
with hands, if there is a provision for an
Right, my lord. So that is still pending in adjudication, my lord. That has not been finalized. It is preliminary stage, my lord.
Item 5.
My lord, if the petition, my lord,
What is the nature of the order?
It's one of the order.
You
It's a,
just read the-
it's a civil suit filed on 7/12/2018 and it is still continuing. And the learned court is
What expedition this was?
yes,
Suit-
expedition.
Suit filed by
7/12/2018.
What is the stage of the suit? What is the stage of the suit?
The stage of the suit is that the learned court is allowing
Or-
time to the plaintiff.
Sir, stage of the suit, it has reached to a peremptory hearing stage. Arguments are advanced, or it is still the pleadings are wanting. What? I wanted to know that.
The plaintiff has not yet exhausted the procedure of service of notice on defendant number 8.
It's not a notice in the suit, it is a service of summons, sir.
Someone, yes.
So, from 2018 to 2025, the summons have not been served. Now, Order 8, Rule 1 has already been amended. Or, sorry, Order 5 is also amended where says 30 days you'll have to put in the requisites. Why? Show us from the order sheet that it is still at the stage of service of summons.
Yes.
Show us
My lord,
from the order sheet.
order sheet at page 1, annexure 1, page
Yes.
9. Advocate for plaintiff files a petition for time hard. Time is allowed put up on 20.
No, this is a consideration of petition. There must be an application. What is that petition?
I have filed the defendant, no one those have filed objection over repeated allowing time.
Sir, probably I am unable to connect a wavelength with you. Sir, when you come for expeditious disposal, the
Yes.
first and foremost thing you'll have to say that what is the stage of the suit? Whether the evidence of the parties has already been recorded or PW1 is recorded, PW2 is recorded, DW1 has not started, whatever, you'll have to show that. And if there is a petition, then you tell me what is the nature of the petition.
The petition is that due to negligence of the plaintiff for service of summon on defendant number 8, we object that this is at least court
I
can
don't know what is the nature of the petition, sir.
nature of a petition to dismiss the writ, dismiss the suit.
Suit on what ground?
Suit for partition and a declaration.
Dismissal of the suit on what ground?
Ground that the plaintiff is unable to serve summons on the defendant number 8.
Then it must be under Order 9, Rule 5. You're talking about this?
Yes.
That they have not put in the requisites for effecting. What is this? Nowadays I am forgetting everything. The CPC talk. Yes. Memory is still there. Order 9, Rule 5. Look at it. Show him the provision.
Only the direction.
No, you should read the provision. Read Rule 5.
Dismissal of suit where summons not served in consequence of plaintiff's failure
to deposit the requisites.
pay
Then,
cost.
so
That happening. Plaintiff is not serving notice on summon on. My simple prayer.
when that petition was filed?
It was filed on 7/12 to 18. Seven 2018.
2018.
18.
Petition for dismissal of the suit for non-service of summons.
It is finally.
When the petition was filed, I just wanted to know, sir, you have simply annexed one order of 10/2/2025, which says that the advocate for the plaintiff files petition for time, heard, time is allowed, put upon 23(6) for consideration of petition. What petition? And when that petition was filed?
Petition I have not got. I will file. It may be urgent to
Sir, you are a civil lawyer. You should know.
May not. It may
I
be-
think the
I may
civil
be
lawyers are more, I would say, very conservative about the procedure. Very meticulous about the pleadings. So, the instant application under Article 227 of the Constitution of India is
Lords. The respondent, who the decree holder, is before Lordship.
degree holder.
Yes, my lord.
Yet not the degree could be executed.
Yes, the appeal is pending since 2019. I pray for the explicit
2019 is otherwise, yes, hearing.
Yes, my lord.
This is an application under Article 227 of the Constitution of India.
May I?
Yes, what is the nature of the order, sir?
My lord, the amendment petition order
Allowed.
6 and 17 has been
Allowed.
rejected.
Rejected?
No, partially allowed and partially rejected despite of the.
Who are you?
I am the plaintiff petitioner, my lord.
What is the suit for?
My lord, suit for is right, title, interest and possession regarding to the position of that. And that has been
confirmation of possession or
confirmation of the possession. Confirmation of the possession, my lord. That has been dismissed. Thereafter, the present that has been dismissed.
Suit dismissed.
Yes, annexure 1, my lord. But thereafter, the present plaintiff as a appellant filed the RFA, and RFA has been remanded to the suit for reconsideration of the suit under certain direction, my lord. That is
a open remand or is a limited remand?
No, my lord, remand to that the petition, the plaintiff should be allowed to add the other parties, misgender and non-gender parties, those who are necessary parties, they must be added. And after that, my lord, it is also directed that he should file the special detail of the suit schedule land and other things which has been crafted, my lord, by an at page, my lord, your lordship. Yes, my lord. The order that the learned trial court should allow the plaintiff to amend the plain so as to incorporate at page 58, my lord. I'm ready. That the learned trial court should allow the plaintiff to amend the plain so as to incorporate proper description of the suit land and also allow to implement the daughters and successor in interest of the dharma. The HAL settlement recorded tenant khata so and so with giving opportunity to defendant number to file additional WS if any further if required. The learned trial court may frame additional issues like if the suit is bad for non-gender of necessary parties and if the suit is hit under Order 7 Rule 3 of the CPC, and then allow the parties to lead evidence and thereafter should do well to dispose of the suit afresh. The learned trial court is requested to complete the whole exercise within a period of 3 months hence, my lord.
You are a plaintiff.
My lord.
Suit was dismissed on the ground of vagueness in the description of the property.
Property, my suit is dismissed. For that, yes, the suit is dismissed, my lord.
Was dismissed.
Yes. On the ground.
On the ground of vagueness of the property and on the ground of misjoinder of necessary party. Or non-joinder of necessary party. What?
The cryptic submission that has been inserted in the suit. That is for that. What happened, my lord? The witnesses in the sale deed is one of the daughter of the property holder, real owner of the property, my lord. In spite of the Kamala, in spite of the Bimala, it has certain amendment, but annexure 3, my lord, my amendment petition I filed.
The signature was done on the sale deed by Bimala or a Kamala.
So my lord, finding the finding of
asking you a question, sir. You are avoiding the answer.
No, my lord.
You say that description was wrongly written. She was a vendor, one of the vendor, or what, or a witness.
My lord, this
Kamala Bimala, this theory, whether she was one of the vendor or a witness to the sale deal.
Witness, who is the daughter of the real owner who has been registered.
So whether Kamala or Bimala is immaterial. Anyhow, the vendor is there. Who has sold the property to you?
Yes, my lord.
Correct.
And that has been muted out of 20 decimal. The half of that is muted. Thereafter, 0.5 decimal has been muted, but another 5.5 is not muted. And it has been again resold to the defendants. Therefore, when the defendants coming and objecting that, therefore the suit is filed, my lord. That is the suit, my lord. Therefore, the learned appellate court find that the pleading is cryptic and confusing description of the suit land is erroneous.
So that is what I say, that there is a vagueness in the description of the property. My English is very bad. Cryptic. Now I borrow this word. Cryptic description of the property.
And the suit is dismissed to that, my lord. There is a
That's
cryptic
why I
description.
asked you, sir.
And yes.
Is it on that ground the suit was dismissed? Because you have the remand was made on 2 grounds.
Yes.
One is that you will precisely and clearly describe the property, which is a mandate under Order 7, Rule 3 of the court.
Well.
And secondly, you will implead the persons who, according to the appellate court, are the necessary party. True?
Yes, yes.
So you went back, liberty was granted to you to amend the pleading.
Yes, my lord.
True. Then you went there, filed an application for amendment.
My lord.
Now, what you wanted, what was the proposed amendment, what you wanted to incorporate?
Yes.
Only description, addition, or what? Tell me.
Yes, my lord. That has been reflected in the order. Even if I have annexed the annexure 3, my lord, the proposed amendment is that in paragraph 7, the impleading the amendment existing the dependent number 2 to 5 added, that has been allowed.
True.
And thereafter, my lord, the proposed amendment is with regard to that, in paragraph 7 of the paragraph 1 of the plaint, in the last part 1 line, Komla be substituted with Bimla. That is that. Then after subparagraph 7, in paragraph 1 of the plaint, the following be inserted, that it is again humbly submitted by the plaintiff that as the dependent number 5 is also an attesting witness to the sale deed in favor of the plaintiff by their deceased mother, as well as all the sisters were very much aware in regard to the alienation.
Dismissal of allowing of the application is that you cannot be permitted to incorporate any statement which is beyond the scope of remand.
My lord.
That is what the court held.
No, the court has given the finding at page 17, my lord, the learned court below. It is seen that plaintiff had clause 2, para 7, 7A, 7B, 7D, and 7E has tried to patch up the lacuna in the plaint, which will make out a new case leading de novo trial, which is not permissible at this stage, as the case has been remanded for a limited purpose. So this court is of the view that
what I said at the very outset, I said, was it an open remand or a limited remand?
Yes, my lord.
Did not understand.
No. My
Tell
lord.
me the operative portion of the appellate court remanding.
Yes, my lord. I am submitting my lord.
Retrial on these issues or any other issue?
No, my lord.
He has framed an issue. He has framed an issue and then say that on these issues,
he may add an additional issue that has been permitted, my lord.
That by addition of rehear the entire matter,
yes,
or restricted to these 2 issues.
No, rehear the afresh. That has been direct, my lord. That I am
read that portion.
My lord, I am reading. But I may be permitted to read only.
Then I have to open.
Page 56.
It's better to open my brief.
No, my lord. Yes, my lord. The finding of the order is the last part, but before I want to draw the kind attention of this honorable prior paragraph, that the pleadings is skeptic and confusing description of the suit land is erroneous. The suit is barred for non-gender of necessary parties like daughters of the Dharmu. Further finding of the learned trial court suffer too from the ambiguity for the reason that on the death of Dharmu, defendant cannot deny the plaintiff's claim of title to the extent of share of the domini at least. On the other hand, as mentioned, the description of the suit
service. You should bring a judgment of the Supreme Court says that if it is an open remand, there is no fetter on the part of the party to allow to amend the pleading. It is only in case of a limited remand when it is restricted to a particular portion, then the difficulty.
Well, it is limited.
Notice it's an open remand. It should to be decided afresh.
Well,
service 2 weeks.
Item 8.
Well, not further proceeding otherwise.
What further proceedings? When is the next date fixed?
On the exactly date is not, but last week of the November. That case is.
We are giving a 2 weeks time to come back.
Item number 8.
Defendant number 1 to 3.
What is the nature of the impugned order?
Suit is for declaration, recovery position, and permit.
What is the nature of the impugned order? You are challenging an order.
Rejection of application under Order 6, Rule 17 of 6.
Amendment.
Yes.
Taken out
Amendment
at
of the
stage. Taken out at what stage?
Now the plaintiff,
While you have taken out the application for amendment at what stage?
after plaintiff evidence is closed.
Close. So suit of which year?
2017.
2000. Proviso?
Yes.
Yes.
That
What?
proviso is there.
Now,
Basically,
due diligence. Show.
But kindly have a glance to my application I have filed before the trial court, that is Annexer 5, page 40.
Yes.
Page 44.
Correct. Show us the ground of due.
Yes,
You have
madam.
shown
I have abhorred.
due diligence.
I have abhorred in my application.
Yes, please.
May I place it, my
Page?
page 44, Annexer 5. May I place it, my?
Not necessary. I'm a very fast reader. Don't worry. When the written statement was filed?
On 2nd of February 2023. Initial written statement was filed. Thereafter,
you are
I am the
you are a
defendant.
defendant.
Defendant number 3 to 4 in the suit. After amendment of the plaint, last I have filed my additional written statement, that is on 2nd of February 2023.
What is the suit for?
Suit for declaration of title, recovery of possession, and permanent injunction.
What is the basis of the claim?
Basis of the claim of the plaintiff is that his great grandfather was the owner of the land. And after the death of his grandfather and father, being the sole heirs of great grandfather, is successor of that.
So you cannot deny that he is one of the co-owner or a co-sharer.
No, my lord. I have my case is that defendant 3 to 5 cases that before the trial court that he is not the great grandson of that
so
alleged recorded.
You have
Yes,
disputed.
yes.
Prove it by evidence.
I have taken a pleadings to that effect.
Paragraph 3 you have denied.
Paragraph 3 I have denied. For elaboration of that fact, I have brought this amendment. What below trial court has said, I have not taken a stand at all. Your lordship will find.
You can adduce an evidence once you
Yes,
denied in denial of the same. You can adduce an evidence.
Yes,
why the pleading is required? Because it is already there. That
only I have
the denial.
In para 3 of my written statement, I have only denied the status of the plaintiff. But here in the present amendment, I have given the details of that plaintiff.
So what is the evidence of the PW1? That plaintiff's evidence?
Evidence I have not got. It's a suit of Badiga, so I have.
There is no ground which you have said. Simply he said that you came to know. When you came to know, what is the source? You have to say.
Yes, I have.
Once the proviso is inserted,
yes,
then we'll have to satisfy that despite due diligence, this was not within your knowledge. Why you could not take out an application for amendment prior to the commencement of trial?
And at that point of time, I have no
Then
knowledge about.
Disclose that when you came to know that nothing has been disclosed in the petition. I have seen containing only 1 or 2 paragraphs.
On filing of the application.
Are you not? This proviso is inserted without amendment.
But the pleadings which I want to incorporate my written statement.
Sir, I understand. This was a situation prior to 2002.
Yes, ma'am.
Then when on the basis of a Malimat committee's recommendation, a proviso is added to Order 6 Rule 70,
yes,
then one has to satisfy.
Yes, ma'am.
It is after the commencement of trial.
I have heard in my application that I have I get knowledge. We get knowledge.
Sir, that's the last line of the first page. When you may have a knowledge prior to the commencement of trial.
No date.
You may have. Sir, we'll have to say.
Since after getting the knowledge, I have immediately filed an application to incorporate.
That is not the scenario, sir.
But I'm relying on the decision of the
Salem Bar Association judgment. You read. What is the purpose of
LIC of India and Sanjeev Builders?
Yes.
Where the Honorable Apex Court has para 71.
Yes. What it says that the court will ignore the proviso.
No.
Then
That is.
Tell me.
71 page. Your Lordship kindly.
Yes.
Para 71, page 35. Last but.
Sir, have you read this judgment? Does it apply in this case?
No,
sir, this relates to the specific relief suit. If a suit for a specific performance of an agreement is filed, and if the plaintiff omits to claim damages or a compensation or refund, then under section 21 and 22 of the Specific Relief Act, it is a duty of the court to ask the plaintiff to amend the plaint. If the court is of the view that he is not going to pass a decree for specific performance of a contract. Once the duty is cast on the court to permit the plaintiff to amend, then this proviso has no application because substantive law gives that right. And the CPC is a procedural law. And this is what has been decided in this case. This cannot apply to a suit simpliciter for declaration of right, title, and interest and recovery of possession.
But the power of court is exercised under
Who
order.
says that the power is not there, but it is circumscribed when the proviso is inserted.
Amendment is to be.
Sir, previously during the pendency of the suit, any stage of the suit. But that's the enabling provision. But then why proviso?
That provision cannot be applicable to plaintiff only and not the defendants. My submission.
It is applicable to both.
Both.
Correct.
So in this case, I have relied this.
I think
maybe the
Order 6 Rule 17 does not talk about plaintiff or a defendant.
No.
It says parties to the suit.
Parties to. But here it is the factual background of the case is different, which I am relying your
Sir, that was a different case where the statute mandates the court that you will permit him to amend.
But here the guidelines.
And when you are going to refuse a specific performance, when a court can come to a finding that I'm not going to grant a degree for specific performance, when everything is over, argument is over, the judgment is to be delivered. At this stage, then the court will permit him that you claim for refund or a compensation.
But
so that is a different scenario.
Exercise is Order 6 Rule 17. The court has exercised the power under Order 6 and the guideline has been.
Is any other provision in the substantive law for amendment? No.
No.
It's only Order 6 Rule 17. So one has to understand in that perspective.
So para 71, the Honorable Court has fixed up the guidelines.
Let me dictate the judgment. When you are so sanguine, then let me.
The factual aspect of the suit may differ from suit to suit, but my submission once a restriction.
Do you have the Civil Procedure Code Amended Act?
Yes.
Amended Act.
Just now I.
No. Do you have the copy of the Amended Act of 2002? Any annotated book?
Right now I don't have. Amended.
No, the central legislation CPC Amendment Act of 2002 by the central government. Amended Act I wanted. I tell you that why you are citing this judgment and where the principles of law which has been laid down, you wanted to rely upon paragraph 71. But in my humble opinion, this judgment has no manner of application. The reason being that this concerns an amendment of a pleading which was filed way back in 1986. The suit which was pending prior to 2002. There is a specific provision under the Amended Act, either Section 13 of the Amendment Act or a Section 20 of the Amended Act, that this amendment will not apply to a suit pending as on the date of the Amended Act. So this was a suit prior to, or it was pending as on the Amended Act. So proviso will not come into play. It will be only an enabling provision which will come into play. But your suit is after the amendment of
2017.
So this judgment has no manner
I may permitted to verify.
I just wanted to quote that provision of the Amended Act, either Section 13 or 20, I do not know. I have to just-
Kindly see from the phone.
Is it Section 20 or something it says?
The Total Amendment Act of 2002.
Give me. Sir, have you seen? This is Section 16, subsection 2, clause B.
I don't have the copy of
It
that.
says that the provision of rules 5, 15, 17, and 18 of Order 6. So it is under Rule 17 of Order 6 of the first schedule as omitted or as the case may be, inserted or substituted by Section 16 of the Code of Civil Procedure Amendment Act 1999 and by Section 7 of the Act shall not apply to in respect of any pleading filed before the commencement of Rule 16. So your pleading was before the commencement of or after. So this was a case that it will not apply because the pleading was before.
You actually keep it to any other.
Any other what? Nothing. You have not shown the due diligence.
Oh, I have not put the date of my knowledge, but immediately after I have abhorred my application that immediately after coming to know about the status of the.
Simply came that later on this defendant made inquiry. When? Why you did not made inquiry earlier? What prompted you to make an inquiry?
But my
what
submission,
prompted you to make an inquiry?
But my submission before.
What was the reason to make an inquiry? Not so easy, sir. The drafting has a very important role in a civil jurisprudence.
That is true, my lord. But what
Sorry.
I am submitting that the fact we want to incorporate will help the court in effectually adjudicate the contention and rival contention made in this. Since a person is claiming that I am the great grandson of the recorded tenant, and our case is that before the trial court is that the land not belongs to the great grandfather of that person. Plaintiff.
You have proposed, with deepest of respect and humility, what you are arguing is contrary to your own stand. You are claim from Punno Singh? Can't. Anyway.
Para 3 of the plaint says he averred that I am the great grandson of Jatia Singh. Now, by way of this amendment, I brought this fact to the knowledge of the
the application for amendment The same is hereby dismissed. Yes, next.
Item 9. My lord, the petitioner filed this application seeking for a direction to the learned trial court to dispose of the petition, which was filed in 2023.
23. What is the
Yes.
stage of the suit?
The notice of substitution is issued against the deceased defendant.
How can we give? Unless the
My-
substitution
my-
is done,
my-
summons to the substituted defendants or I do not know.
The background of the case is like this, my lord. The application under Order 7, Rule 11 filed by the present defendant. The
Who died?
other defendant died.
So what?
Some of the defendant died.
But the suit
We
is
are-
as a whole.
But
But the suit is as a whole.
this is a dependent character suit.
Are
ma'am.
they representative?
Yes, ma'am.
Leave
And
under
the-
Order 1 Rule 8 taken.
Order 1, Rule 8.
Taken.
Yes, ma'am.
Leave taken.
Yes, yes. They have like, taken, plenty have taken the leave of the court. And after filing of the suit, only 2 plaintiffs are there. They have filed the suit. After publication of the notice, perhaps
How
295
many
persons
applied for addition? How many applied for addition?
295.
Help us. Good.
The entire villagers. So therefore, we are the contesting opposite party in the suit because the property belongs to us.
Say under what ground?
Right?
On what ground?
Right.
Non-disclosure of the cause of action or barred by law?
Suppression of material facts.
Does it come under Order 7 Rule 11?
Yes, ma'am. It is barred by law in view of the fact.
That is a barred by law.
Yes, ma'am.
Tell me suppression is a law.
When in the suit, they may I bring to lordship to the prayer made in the plaint. They have prayed for to declare the judgment and decree passed in the earlier suit be declared as void. Even though
Bar. Where is the bar?
my bar is the second appeal is now pending before this honorable court.
So what?
Again, between the same parties and in respect of self-same property. Now,
Then the proper course is Section 10.
so for the other, they have prayed.
How Order 7 Rule 11 lies, I do not know.
My lord, the
Can't be
prayer,
barred.
the prayer in the suit is the right and interest of the plaintiff as well as the entire Christian community of Khorda over the suit property be declared.
Correct.
Right.
So that it is maintainable suit for declaration of title.
Another suit was filed that was dismissed.
For?
Declaration of right and interest.
No. Dismiss means on merit. On
Yes, a merit matter. Declaring the learned trial court in the earlier suit declared that the plaintiffs have no right to the property. They have challenged in appeal. Appeal has also been dismissed. They have challenged in second appeal.
Pending.
Second appeal is pending.
So
after 2 months filing of the second appeal, they have filed another suit by another group of persons.
So they are the third party. They are not a party to the proceeding.
Like the person who filed the second appeal.
First suit was a class action or it was an individual suit?
First suit is on behalf of the entire community of the society.
It was also filed after
Under dependent character suit, man.
representative.
Yes, ma'am.
Order 1 Rule 10.
Yes.
Then it is binding on all.
Yes, ma'am. Irrespective of that, the second suit is filed after filing of this. The second appeal before the High Court.
Notice after 3 weeks.
Item number 10.
But we sought for a direction only to the learned trial court to dispose of the application. That application is pending.
They are entitled to plaintiffs. Let us.
They have already been heard, man. Plaintiffs have already been heard there in that court. That application on Order 7 has not yet been disposed of for last 1 year. The application was filed in 2023. And the objection was filed.
Let us hear them, then we'll definitely serve the notice on this original plaintiff.
Item number 10.
Well, item 10 expresses disposal of the suit. Suit was of the year 2008. And stage of the suit is that witnesses from the side of the plaintiff already examined, cross-examined and discharged.
And defendants?
Defendants, they are not bringing their witnesses for examination. And they have completed the evidence from my side has already completed since February 2025.
This is an application under Article 227 of the Constitution of India. Who is? Where is it?
So my senior is speaking now.
Oh.
My lord, and are online, my lord. I may be permitted to submit. My lord, it's a case order. My lord, order for my lord, additional evidence, my lord, at the stage of the appeal, my lord.
It is taken in isolation.
It is taken in isolation.
Notice. When is the next date fixed?
My lord, the last date was, my lord, 4th of this month. And thereafter, my lord, I am yet to obtain. But 4th of this November.
I am giving you shorter time, 2 weeks come after notice.
Item
My lord,
12.
there is a prayer for stay, my lord.
I understand. That's why I asked you this question, when is the next date?
And it was on 4th. This
will not stay in that way. Anyhow.
Item 12.
May I please, Your Lords? This is a case. I have filed a suit for petition. In between the co-sharers, there is defendant.
Application.
Application 39(1) and 2 was filed before the trial court. The trial court granted an order of status quo. That order was the subject matter of challenge on Order 43, Rule 1 before the decision at the instance of the defendant, other defendants.
It was a final disposal of the application for injunction or interim?
Final injunction application has been final disposal.
Then what?
They are challenging. Appellate court says, Your Lordship, he has filed an application along with that first appeal, FAO, that I may be permitted to complete the construction which has been made.
What was the nature of the construction?
Nature of the construction, my lord, these opposite parties, 18 to 23 in the defendant, they are in permissive possession of our land, so that we have sought for a eviction against them and partition against the defendant 1 to 70. The nature of he is no way, no right, title or interest of these persons over the property except the co-sharers. I have filed the suit.
No, you have said that they are the permissive occupant.
Right.
They are the
By one of the
occupant. What is their defense?
They are also admitting that they are not able to show any document.
I am asking you, what is their defense?
Their defense, my lord, they are saying that to of the property. Only that.
They are in the possession of the property. Since when?
Since because one of our co-sharers instructed them to look after the property, to look after a portion of the property. And after the death of the person, his sons are constructing the house over that property.
Correct. So in that event, what is the stage of the construction?
Well, stage of the construction, they have made some pillars.
It's simple pillar, or it has
only
come up fully, except some few work.
Only pillars
is required.
Only pillars. What the appellate court has stated. And the London appellate court has status quo. In spite of the status quo order, London appellate court varies that order and allows him to construct on your lords. Page 64 is the order influence of the page 64, relevant portion. It starts page because, my lord, he has started the construction who have held the suit for eviction of those persons.
No, that is true.
One question, your lordship. The appellate court, while sitting under Order 43, Rule 1R, your lordship, can interfere and distinguish My lord, what this is a question reminding on me, your lordship. Can distinguish the fact which has been appreciated and adjudicated by the trial court.
Then what is the purpose of setting up the appellate court?
Then
if the appellate courts are bound by whatever has been said by the
No,
court,
then
then there is no question
no,
of
no,
any remedy by way of appeal to the higher forum.
my lord, I'm not saying that. My submission is that the entire fact which has been said, that the three principles of prima facie case and all the two balance of convenience, then the irreparable loss. That has been then your lordship conducted.
Everybody says
My lord.
three. I coined it fourth.
My lord, absolutely correct.
The fourth one is the court
And-
will also consider whether
My-
it has a jurisdiction to
Grant.
decide.
My lord, absolutely.
That principles will also be considered.
My
If it lacks inherent jurisdiction, then
My lord. Then
prima facie case, irreparable loss and injury, balance of convenience, inconvenience has no meaning.
That's absolutely right, your lordship. And another judgment is for the conduct of the parties is also relevant fact.
Yes.
Conduct of the parties is also relevant fact. Some of the judgments say conduct of the parties. Is one of the consideration for deciding 39(1) input. Whatever. That three aspects has been analyzed by the trial court in extension. Same set of things and facts have been advanced that I want to make a construction over the land. And
I ask this question because there is a judgment of the apex court delivered by Justice S.B. Sinha, which is reported in 2008, volume 11, SCC, page 1.
Wonderful.
It says in paragraph 23 or 24 of the judgment, which says that if the construction has come up, whether it has rightly been come up or not, the court will not pass any injunction order and can only put a rider that in the event he wanted to create a third party interest or he wanted to sell the property to a third party, the conveyance or the detail which he will execute will reflect that it is a
Right.
subject to the result of that suit.
Equity. He shall not claim any equity.
It's only equitable. That's the reason being that a purchaser of that property will not claim a equitable defense which is available to him under the law, that a bona fide purchaser for value without notice. That I had no notice, I am a bona fide purchaser,
Right.
for value I have paid, so equitable defense. That
Right.
was the reason. That's why I am asking you.
My lord.
And what proposition you are saying, then it makes the appellate court a rubber seal court. Appellate court will definitely go into the question whether the trial court's perception of the prima facie case having made out is correct or not.
Correct or not, yeah, lord.
He can definitely go whether the balance of convenience and inconvenience lies in favor of a person applying for injunction. He can also consider who will suffer the loss immensely. There is no difficulty. He can enter. It's the first court of appeal.
My lord.
Can enter.
Then your lordship, this your lordship perception, your lordship just have a glance what the first appellate court's order, your lordship. First appellate court's order. My lord,
He has said that he will not claim any equity. What he says. That's why I'm harping on you. What is the stage of construction? Because of that judgment of Justice S.B. Sinha.
2008.
8, volume 11, SCC, page 1. Do you have the copy here? One.
I'll examine this. But next week, soon. Let it come on next week, your lordship will examine that lot. I have also come up with other judgments, your lordship. That your lordship, I know that equity, but your lordship is not having any, even your lordship, right over that. Only possession.
What I'm saying, there also the dispute was in relation to a right.
Can such right can be subsequently? Suppose he cannot claim any equity.
There are another. the possession is a 9th principle of title as well. Is a 9th principle of title. So if the person who is in settled possession, he cannot be evicted without due process of law.
Right.
Section 6 principles of the Specific Relief Act, you are aware.
Yes, ma'am.
So no country or the law permits anybody to take the law in his own hand. You have to go. You have gone there. You have claimed a better title.
Absolutely.
You have claimed a better title than him. But one thing is, you are branding him as a permissive occupant. He is claiming that I am in a settled position because one of the co-sharer has inducted me as a tenant. Must have.
To look after that, yes, whatever it may.
Whatever
Yes.
is the reason, he has, say, a protected right.
Hmm.
I have got no contractual obligations. That's a principal privity of contract and the privity of state. You may have a privity of state, but you do not have a privity of contract.
The reason
A co-sharer has an equal right which the other co-sharer has. You can't claim. There is no division in that regard. In every molecule or inch of the property,
Right.
there is a jointness.
Whereas he is also not even a co-sharer. He's a totally
Your co-sharer
Mine,
has given
mine,
him.
mine.
Sir.
Mine, mine,
So he's claiming an authority from a
From
person
mine.
having a right in the property.
The source of the authority from
So
one of the
that is
co-sharer.
what I mean. He has a privity of contract with him.
He has also
There is
come
no
up with
privity
me.
of contract with you.
Well, he has also come up with me to file the suit for eviction. My co-sharer has also come up with me to file a suit for eviction.
No, not
He has not
difficulty.
filed.
Go there. I was telling, read 2 paragraphs. I was saying paragraph 26 and 27. Just read.
Well, it needs some preparation, Lord.
I am telling you 26 and 27. Please read it. Last paragraph. Rightly or wrongly, look at it.
Rightly or wrongly, constructions have come up. They cannot be directed to be demolished, at least at this stage. Respondent number 7 is said to have spent 3 crores of rupees. If that be so, in our opinion, it would not be proper to stop further construction. We therefore are of the opinion that the interest of justice should be sufficient while allowing the respondents to carry out constructions of the buildings. The same is made subject to the ultimate decision of the suit. The trial court is requested to hear out and dispose of the suit as early as it is.
Another. Go further.
If any third-party interest is created upon completion of the constructions, the deeds in question shall clearly stipulate that the matter is sub judice and all sales shall be subject to the ultimate decision of the suit. All parties must cooperate in the early hearing and disposal of the suit.
So
the respondent was asked
was
of sufficient security.
So the injunction was not granted. That's why I wanted a stage of construction.
Stage of construction, I'll appreciate to your lordship of the day. On
So
that,
he has said no equity. That's the principle which is laid down in this judgment as well.
because it is, I think you will say, it is lease deed has sought to be by virtue of a lease deed. I have not read the entire judgment here, sir. He is claiming certain construction.
Sir, don't invite me to more. When you talk about lease, then you should also know what is this. Lease is not a transfer under section 105 of the TP Act. Tell me, it's an incident of transfer. So, why is a lease deed?
Well, let me prepare myself from on that score, dear lords. Let me prepare myself.
Don't hurl in the air. Come ready.
Right.
Okay. It's nothing. Ultimately, it will succeed. No difficult. There is another judgment of 2009 also, presided over by Justice Torun Chatterjee. I think 2009-13 or 2009-12. Same principles.
Well, okay. I'll make myself prepare.
I lost.
Before the Calcutta High Court.
Anyhow.
Right.
Next.
Item 14.
May I please, Lordship, on behalf of Mrs. Das, seeking for an adjournment due to some medical emergency.
That's the greatest opportunity for the juniors to move. Move.
Sorry, my lord, actually no instruction.
Instruction. You are one of the advocate and record.
No.
You have executed the Vakalandama, signed the Vakalandama.
No.
You're not.
Yes, no.
Next week, next.
Oblige, my lord.
Item 15.
Item 15 on behalf of Mr. Mante, who is in accommodation, would like to seek an adjournment. I do not have power to reproduction.
Next.
Item 16.
Hearing Lord, an application for amendment of the plaint has been rejected.
Amendment of?
The plaint.
Plaint.
The suit has
What
not.
stage?
Commencement of hearing has not started.
Why it is rejected? It will
Rejected.
change the nature and character or what?
In fact, there is no such
Reason.
reason is there. In fact, this is a suit for recovery of money. Earlier, I made a claim of around 38 lakhs amount. By way of amendment, I am reducing my claim. I am reducing my claim to 13 lakhs. But because I could not pay the total court fee earlier, because for the deficit of court fee it is continuing, the learned trial court says that because of non-payment of court fee, I am reducing. Anyway, I am reducing my claim because of the fact that there was a revelation that in a subsequently consumer proceeding, some amount have been paid to me.
Now 2 weeks.
Now the suit has been posted 15th/11 for payment of the deficit court fees. Lord, unless it is state Lord is claiming that you should pay the court fee, otherwise the suit will be rejected. Plaint will be rejected. 15th tomorrow it is fixed.
Liberty is granted to the petitioner to pray for an adjournment before the trial court.
Yes, no problem. Obliged.
On the ground that this original application is pending, as we find that the suit is posted
Item number 17.
next.
Item number 18.
Yes. In limited defense, the already the someone is duly served upon the defendants. But the matter is not proceeded with. Suit is not proceeded with. The
Written statement filed.
Petitioner is the plaintiff.
Written statement filed.
No. They are not appearing. They have not appeared.
Who is not appearing?
The law and court below.
Sir, you say that the summons have been served upon the defendants.
And the law and court below is to file a service affidavit and for fresh step. But when the service process server has on affirmation filed that he has already served the notice upon the defendants as per 15 my lord.
No, this was on 17/3/25. Now we are, sir, in November 2025. What has happened in the meantime?
The suit is not proceeded.
No. What is the next date? You'll have to say. This is what a service through court. That's the process server. Through process. But what about the other mode? By registered post. What is the other mode? What has happened to that?
Already process server has served the notice.
Process server. Yes, what the court has said that the process server service is not supported by an affidavit. Let us forget. What about the postal? Has it returned unserved or served? Ascertained. 1 week. Next.
19.
Yes.
Here, the plaintiff is before my lord because of inaction of the learned civil judge.
in disposing of the petition dated 21/2024 by the Annexure 2 series, my lord. My lord, the defendant number 7 and 8 were allowed to, because they failed to file the written statement within the stipulated period. The learned court, by the order dated 24, Lords may kindly turn to page 35, 24 August 2024, passed a specific direction they can participate in the proceeding, but they are precluded from filing written statement.
What is the meaning there?
My lord, that the order, that means they can.
They can't cross-examine.
They cross-examine.
They can cross-examine.
Can cross-examine, but subject to only challenging the veracity of the witness, truthness or otherwise. They cannot lead evidence. That is the purport of the meaning of precluding the written filing of the written.
Has their defense been struck off?
No, they never filed. My lord, written
statements are not struck off.
My lord, striking of the defense only arise if they file a written statement.
No, that it will not. Only thing is, I am concerned about AI 1980 Supreme Court, which the defense is struck off. You are permitted to cross-examine, but you will not be able to lead an evidence.
Lord, that is a different aspect, because by order of the court, the written statement which was filed.
Written statement is not filed within the time.
Miller.
But still, he is permitted to participate
in the proceedings. Yes,
Miller,
that is the order.
What more?
That is the order passed on 24 August.
What is the grievance?
The grievance is that, my lord, thereafter they appeared, my lord, instead of filing an application to recall that order, they filed a written statement cum counterclaim, and there is no. They have filed a petition to accept the written statement. That is pending for consideration, and the court has directed that the office note on the counterclaim be made, my lord. So my grievance.
This hearing was concluded. Now it is fixed for orders on 15/5. What happened?
15/5. Lords may kindly say the 15. The order is fixed on the office note, my lord. It is regarding the payment of court fee, my lord. He is not disposing of the petition filed by the defendant number 7 and 8 for acceptance. I filed my objection. That petition remained pending, and the learned court is proceeding ahead as if a counterclaim is there. That is my grievance.
You bring him, we'll pass an order in his presence, because there will be some stringent order that would be passed, should not be passed on. Yes, service 2 weeks.
Item 20.
May permitted to only take services against defendant number 7 and 8 through speed post, because their application pending for consideration, and the court is not disposing of the same. That is my grievance in short before your action.
Notice on restricted to 6/7. 7 and 8 or 6/7?
Thereafter, he filed an application on order 9/13. That was also dismissed. Then, yes, then an appeal is pending, order 43(1)D, before the learned decisions. In the meantime, this appeal was transferred from the principal court to another court, because a new court was opened in Jaleshwar, Nilgiri. There, I had to file an application for interim protection, because the opposite parties, they are disturbing possession and trying to make construction. Repeatedly, that application is being dismissed on the ground that the notice has not been made sufficient, because prior to that, before the principal court, notice was made sufficient. Learned trial court, now to which the case has been transferred, he has directed fresh issuance of notice, because somehow the matter has been.
There is no impediment on the court to also consider the.
Yes, that is exactly. Kindly have a glance, page 44. That application is being rejected outright, because the page 44. Accordingly, petition stands rejected. No cost put up on the dashboard for awaiting SR and PA. It is being posted for service return, and that is when the interim application is not being considered. Lordship may make an observation, I can file a fresh application that will be considered on its own merit. I am not saying that he should pass an order in my favor. Now the case has been fixed to 19/11/25.
No, earlier application was also dismissed.
Dismissed, same ground.
What ground?
It awaiting for service return.
No, where is then why you did not challenge the earlier ground also?
No, that was not challenged because I
No, sir. That was a 4/9/2025 order. You ought to have challenged.
Yes. That was this such a
So you are within time, no difficulty. Challenge it. No period of limitation for 1/2/27. Bring both the orders, otherwise it will be a difficult one. Otherwise, the res judicata will come and that will apply. Yeah, both come.
Should it be adjourned?
Adjourned for a week.
Item 22.
My lord, the Civil Court Commissioner tendered evidence as C11 in the execution proceeding, and on that day the counsel for the JDR could not cross-examine as his sister was expired and he was busy in performing the last rite, and prayer was moved for adjournment. And on the next date, and he posted the case record and for acceptance of report of the civil commissioner and rejected the prayer of the petitioner to cross-examine
You
the.
wanted to cross-examine the court commissioner.
My lord.
Commissioner appointed under order 39/7 or order 26/9.
Well, that is the after the final decree, my lord.
Is a partition suit?
No, suit for permanent injunction, my lord. Permanent injunction, my lord.
Permanent injunction.
My
So the commissioner must have been appointed under order 39.
Yes, my lord. Commissioner
or 26/9.
When order 26, my rule 9.
For inspection, advocate commissioner or some survey pass commissioner under order 26/9. I just wanted to know. Sir, come ready.
My lord.
Please prepare yourself. Come ready with the facts.
Well, next week, my lord.
Yes.
23.
May I please know?
Yes, sir.
The plaintiffs are the petitioners before your lordships.
What is the nature of the order?
My lord, permission was not granted in favor of the plaintiff, but status quo order was granted. But the learned lower appellate court vacated that order. The plaintiffs have filed the suit for.
On what ground?
The learned lower appellate court said there are alternative way, and the alternative way which has been referred to, that is one a government land, and that other land which has been referred to, that belongs to some other party. So my claim is that the petitioners, the plaintiffs as well as the defendants, they purchase land from the joint co-owners. And in the cell deed also, it has been reflected that the cell deed which was purchased by the defendants, there was a mention that 7 Kodi Rasta road space has been given to them in the cell deed. In the cell deed specifically is mentioned that there is a road, and the learned trial court is referred to that. In my cell deed also, and as well in their cell deed, the learned trial court referred to the cell deed and say whether there exists a spaces or not. This will be done during the course of hearing of the case. Now, at present, directed both the parties to maintain status quo. The lower appellate court say since the opposite party's case is there, there is an alternative way in which.
It's not a case of prescription or easementary right on prescription or by
yes,
necessity.
My case was easementary right of prescription.
Yes.
Well,
It's a clear case of a boundary dispute which has to be assessed.
Exactly.
Whether this Rasta comes or not.
24.
An application for transposition filed by defendant 5 to the category of plaintiff from defendant 5.
Why you wanted to become a plaintiff?
The plaintiff
has sold the property to you.
No, Lord. The plaintiff suit is for declaration of right of easement over the government land. So also seeking over the government land. So also
His right, he has claimed over the government land. In what capacity?
Right easement of road over the government land. So also seeks injunction against me, the private party, not to obstruct the passage. I filed my objection saying that I have also right to approach the main road through that government road. The plaintiff has filed an application to withdraw the suit. Thereafter, I filed an application to transpose me to the category of plaintiff since the plaintiff seeks withdrawal. Without considering my application for transposition, the trial court has been pleased to withdraw the suit, and in my application has said that the suit has been withdrawn. Therefore, my application was rejected.
Have you admitted the claim of the plaintiff?
No, my lord. My claim is that over that only piece of land I have.
Consider in the next week, come ready.
I will.
Otherwise, problem.
Item 25.
Item 25, may I pray your lordship can take next week on behalf of Mr. Mishra. Your
Next.
lordship.
26.
26, Your Lord. An application to recall a witness is pending since 2024. 17/5/2024 it was filed. Till date, it's not being disposed of. That is my only grievance.
What is the next date?
To recall a witness, it was filed.
Which defendant's witness?
This is my plaintiff's witness.
Plaintiff's witness. But, this is an application under Article 227 of the Constitution.
Kindly take care of next week.
Next.
Item 28.
My lords, I appear for in item number 27. I appear for IOCL. The main counsel is unavailable due to personal difficulty. He seeks 4 weeks time to file his response.
27 has already been adjourned. Anyhow, 28.
28.
Your Lordship, may kindly see the Hide Annexure 1 from running page 11 to 13.
What is the nature of the order you are impugning?
The nature of order, the impugned order, Hide Annexure 1, passed by the court below under order 39 rule 3 of CPC.
Under
order 39 rule 3. Before granting injunction, direct notice to the opposite party. Without notice, court passed order.
Sir, exception is also there. I was just
Yes, sir.
really
Just
an application under order 39 rule 3 is maintainable. This is for the first time I come to know.
No, Your Lordship.
I know actions in other provision. Order 39 rule 3 says that the court shall not pass any order of injunction without giving notice to the defendant.
Yes,
Exception is that if the court say that the delay would defeat the very purpose, then the court must record a reason for granting
No,
the
I have come by challenging the impugned order in which the court below extend its status quo in prohibitory order, ex parte prohibitory order, without giving an affordable opportunity after a elapse of 1 month. Sir, very order 39 rule 3 is very clear.
No, it says as it should be ensured
let
within
me
1 month. Where is the Justice Rumapa's judgment of the Supreme Court?
No, your lordship.
But
no, your lordship.
it has been diluted.
No, what is the intention of legislature? Normally,
Secondly,
sir,
you are challenging an order passed under Order 39, Rule 1 and 2.
No. Rule 1 and 2, of course, pending. The against Rule 3, order of Rule 3.
Order of the Rule 3.
Rule 3, sir.
Where is the
I have
order? Where is the order? Tell me.
Please,
Let me
on
see.
side Annex 1, page number, running page number 11 to 13. Order passed dated 5th September 2018.
5th September.
Again. Lord advocate for the petitioner is present, examine the office note, had admit the petitioner has filed an application under 39(1) and 2, read with section 151, thereby praying to pass an order of a hard interim injunction restrain the opposite party from interfering on the peaceful person of the petitioner in respect of the suit settled property, and or the make
No, this I do not know. Page 13.
Page 13, the last portion of the order. On the documents that code that the object of the granting injunction would be defeated by delay, it would be not taken as urgent. Hence, the petition filed by the petitioner for issuance of order of ex parte injunction is to be allowed. Both the parties are directed to maintain status quo over the suit land till 19th-9/2018.
So that has been allowed.
That petition was allowed, and that petition was allowed by the court in absence of me. At that stage, I was not present before the court. I was not entered appearance. I had not entered appearance, and in my absence, that order was
this order is how this order is revisable.
Now, because, sir, let me say the Rule 3A, the newly inserted by the legislature, Rule 3A, Order 39 of Order 39, in which the legislature intention is very clear. The which order was passed by the court below as per under Order 39(3), the order be disposed of that application within 1 month from the date of passing of it.
Correct.
And but what happened? The court below did not consider my application by the Annexure 2, page number 14 to 20, which petition filed before the court below in order to set aside the, in order to dispose of the application, because that order should not be continued indefinite period.
D'accord. A order a
Sorry,
chamber. I am groomed in a chamber which deprecates. Now I'm saying with command, which deprecates. Where is that?
Another judgment.
Serve the notice. Notice 2 weeks.
My lord,
Item 29.
my lord, may I please?
Suit can.
I'm challenging the order 1940 of District Court Kalahandi Bhavani Patna without honoring my delay. To honor my delay.
What delay? Delay in?
Delay in 8 years for 9 months.
Oh,
9 days.
what?
On appeal, my lord. On CMA 30 of 2024.
It's a regular appeal, first appeal.
The first appeal, my lord.
So it must be FA.
FA, my lord.
FA or CM? What's the one?
I came CMP, my lord.
Oh, this is KP counts. Look, a judgment When is the next date fixed?
Yesterday the date was fixed. I have not ascertained when.
2 weeks, time, shorter time, we have.
Problem.
You,
The next few months. Yes.
your lord.